The Justice and Correctional Services Minister has set up an advisory committee to look into fees charged by lawyers. In a statement, Minister Michael Masuta says the team is part of measures that government is continuing to take to ensure access to justice for all. The committee will begin work immediately and has 2 years to complete its findings. Justice and Correctional Services Minister Michael Masuta joins us now. Minister, thank you very much for your time. Just as a bit of background to this decision, what informed it?
Well, as you correctly said, this is part of a series of measures that we've been adopting, in part carrying on the work of my predecessors. We've been expanding the infrastructure of the courts by building new courts, especially in historically disadvantaged areas. We've been rationalizing the jurisdiction of these courts to ensure greater access where people can access courts closest to where they live, etc. But there's always been this sticky point around the cost of litigation in South Africa, which has kept on spiraling to a point that even your middle-income earners find it extremely difficult to access legal services from their own pocket because of the ever-escalating cost. So the purpose, we started this conversation back in 2014 when we took office as one of the immediate interventions, where we requested the South African Law Review Commission, which deals with investigations into the development of the law, to look into this matter. There has been an interim committee that's been working on this, but now with also having received additional funding from overseas donors, we are now in a position to put together a fully fledged advisory committee that would work flat out to come up with concrete proposals for measures, be they statutory reforms or other interventions that will enable us to really rein in the spiraling runaway costs of litigation.
Is costs, though, Minister, the only sticky point, as you put it, for people to access justice? Because the running of the lower courts in particular has been a big problem as well.
Well, like I said, it's one of a series of measures. Inefficiencies in our courts, which are the result not only of challenges with the courts themselves, but other processes and structural or institutional support to courts have been factors which has, as you have identified, affected the efficiency and effective running of courts. So that is a different process. I mean, whether you talk about infrastructural challenges, issues of technology that sometimes is not always reliable because of various challenges, automation and the need to actually modernize our justice system overall have been some of the things that have been introduced to improve speed with which services are rendered, the efficiency thereof, but along the way there's been teething problems. Like I said, issues of distance. You'd recall that 2 years ago we opened a new high court for Limpopo, which was one of the only 2 provinces in South Africa that didn't have their own dedicated high court. We will be opening a new high court for Mpumalanga during the current financial year, and a number of new magistrates' courts, no less than 4, in the current financial year, as well as the refurbishing of others around the country and put them to to use so that the physical infrastructure makes it more accessible. There's also challenges of the time it takes for matters because of the clogging of the court rules, because of increased litigation in our courts as well. And those are some of the challenges that we've been looking at. But this one is specifically looking at the economics of justice. Is justice accessible to South Africans financially?
Okay, a quick one, Minister. I mean, looking at the composition of the committee, the courts, academia, your department seem like well represented. Do you not think you may have robbed this committee of the experiences of both the victims and survivors? For instance, couldn't you have gone to organizations like the Legal Resources Center, for example, and get them to be involved as well, to come with that victims and survivors perspective?
Well, I think that what is at issue here is the technical work that needs to be done to develop, you know, a clear composite, comprehensive study of the subject. Obviously, given the vested interests involved, we have to be particularly detailed in the manner in which we investigate the issues and the manner in which we deal with the different competing interests. So, well, maybe you may have a point that we could have been more inclusive in terms of different constituencies. But I think the process here really was people who have the technical skills who would be able to produce the product that we can then put out for consultation. And that stage, we would then be able to, having developed some initial discussion document, to engage different sectors and interest groups for their input. So they would actually be included in the process of finalizing the policy. Okay,
Minister, before I let you go, I want to play you a clip from former NPA director, from the former National Director of Public Prosecutions, Mxolisi Nxasana. If you can just take a listen, and I'll ask for your response.
Again, Mr. Masuta also owes me an apology for the things that he confirmed under oath in an affidavit about me, which he knew very well at the time when he made those affirmations about me, that they were not correct.
Do you feel you owe Mr. Nxasana an apology, Minister?
I'm really not sure what Mr. Nxasana, with respect, is referring to in particular. I have given an account of the interactions, the personal interactions that I had with him during the process leading to his resignation. Let me make it very clear that our discussions with Mr. Nxasana, and he will confirm it, was confined to him giving me an update as to his decision regarding his impending resignation, which I would similarly convey, you know, those updates to the President, whether he was still in the process of consulting his family or was in the process of consulting his lawyer. That's what he would convey. I mean, that's what I would convey to the former President. The issue of his retirement or resignation package, I want to make it very clear, and he knows it. At no stage did we ever have a conversation between me and him regarding it. whether there was a package, what the content of that package would be, until the time when, after a negotiated settlement between his lawyers and the former president's lawyers, I was presented with a final a text of the agreement that had been entered into between himself and the president, and in my official capacity, I signed on behalf of the state that agreement. And just to clarify that there are matters where I exercise authority under the Constitution or any particular act of parliament that gives me that specific power, but quite differently from that, any administrative process where the president exercises his executive authority in relation to administration of justice, those processes have to be, I have to give administrative support to the president. So whether it's a proclamation that must be published by the president that has anything to do with administration of justice, I have to sign off, countersign that draft proclamation before it can reach the president so that he can promulgate it. So I do not have the authority to tell a sitting head of state when they exercise their constitutional or legislative authority what decision to take if the decision is not mine to make. It's only where the law entrusts that responsibility in me, and of course where my advice is solicited by the head of state, of course I'd give that advice. But the head of state doesn't have to, when they exercise their authority under the law, the Constitution, to take my advice. They can make decisions, but I have a duty to ensure that that is given effect to by ensuring that the necessary administrative support is provided for that to be effected, as long as it has to do with the administration of justice.
Minister, the president may well have exercised his constitutional or whatever duties, but when you put your signature to that document, did you sign knowing very well that what the deal was in fact illegal? One. And two, did you advise the president at any point that even though I'm signing this because it's outside of my powers, I think what you're doing is wrong? Did you do any of those things?
It was not put to me how the amounts were arrived at, how the calculations were done. These were matters that had been concluded elsewhere between the legal advisors of the president and the legal advisors of Mr. Nxasana, as I understood it, because at no stage was I ever invited or made privy to those discussions, and where I would have understood how those calculations were arrived at. So mine was merely to facilitate, because the alternative would have been not to provide that administrative support, in which case then the president wouldn't have been able to exercise his powers, and obviously that would have amounted to an obstruction on my part, and of course you know, it would have been unreasonable of me, especially having been given the understanding that, first of all, we're dealing with a person who was heading the institution and was therefore responsible for the administration of that law, the National Prosecuting Authority, in terms of which the settlement was made. Secondly, he was legally represented. Thirdly, there was a legal representative of the former president who, in representing the president's interest, would have engaged in finalizing all the technical detail. And of course, they had access to all relevant government institutions for advice in constituting that. So I was in no position under the circumstances to doubt that all the necessary prescripts had been followed in arriving at that settlement. In any case, I wasn't invited to express an opinion or to investigate whether or not that agreement was conforming.
But quickly, Minister, did you, as Michael Masuta, the Minister of Justice, know at the point at which you signed whether this deal could be wrong or illegal?
Not at all, and I had no reason to doubt it. I had understood that similar settlements had been arrived at, be it of different amounts. And as I sit here, I don't even know whether previous similar settlements were themselves conforming to the observations made by this judgment in this instance. But of course, those are not the subject matter at this point in time. But all I can indicate is that I had absolutely no reason to doubt that between the legal teams in the presidency and in Mr. Ngasana, all of whom had the interests of their respective clients, and I assume the interests of the state at heart, would have had any reason, knowingly or deliberately, to enter into an agreement that was illegal. And therefore, I equally had no reason to suspect or doubt that there could have been any error in interpreting the law or applying the law in arriving at the settlement.
Minister, thank you very much for it.